Hey everybody, welcome to today's Cathedra webinar. We are coming to you live on July 23rd, 2025. You're tuning in for day 3 of the 5-day series on NAHASDA Tribal Council Role and Responsibilities. Again, this is day 3 of 5, so hopefully we got some returners from day 1 and 2, and hopefully we can see more of you tomorrow for day 4 and Friday for day 5. My name is Brooke Warrington. I'm the Training and Development Specialist here at the Native Learning Center. We're also thrilled you could tune in for the webinar with us today. If you could follow along while I read the disclaimer aloud. This webinar provides a summary of fundamental concepts, requirements, and/or procedures within the allotted 90 minutes. The material discussed does not illustrate all possible scenarios that could be applicable. We also have our copyright law printed here. Sorry about that. The webinar materials are protected by copyright, trademark, trade secret, and other intellectual property laws. So just a friendly reminder. If you are looking for any of the course materials, particularly the recordings or the extensive list of resource materials that Cheryl put together for you, you can find all of that in the courses section. If you go to Tribal Council Roles and Responsibilities under NAHASDA, that course in the courses list, you'll be able to access the recordings as well as a PDF of the slides of the days that have already happened. I have put a link to today's presentation slides for you in the chat. And then tomorrow when you tune in for day 4 and Friday when you tune in for day 5, you'll just log in like you did today and you'll click on that green banner at the top of the screen. We ask that you join with listen-only capabilities. Just helps us to cut down on any audio feedback for our instructors. And if you find that my voice is coming out of the wrong device, maybe you're trying to use your headphones, maybe you have a Bluetooth speaker, whatever the case may be, you could click on that little telephone icon down at the bottom of your screen, and that does bring up a list of your mic and your speaker devices, so you can select the correct audio output. We do, of course, encourage class participation. We want to hear those comments, those questions, so we'll primarily rely on the public chat. If you don't yet have that open, if you look at your gray messages panel, you can click on public chat and then it'll look like what I have on the screen here. You'll come down to the box where it says send message to public chat and you can type in your question or your comment. If you're having any tech support problems, I can try to help navigate you through the chat as well. Just say what you want to say and hit enter, or you can click on the cute little paper airplane button and that'll send it into the chat. With Cheryl's presentations, typically she's going to answer your question as she continues to go through her material. But if you are afraid you're going to maybe forget your question later, you could always send it in early. And if you did join and you're unmuted, you can always mute yourself by clicking on that little mic icon down at the bottom of the screen. Last thing on this slide is that we do have the shared notes section. If you go in there, that's going to bring up a list of helpful links for you, including today's webinar feedback survey, again, the link to the slides, a link to our webinar archive on YouTube, just different things like that. We'd love if you take a moment to introduce yourselves in the chat now before we get started. Again, you just click on that box and then type what you want to say. You could let us know your name, where you're tuning in from. It's always fun to see all the different tribal nations that are represented, your work or your role in Indian country that probably led you to today's webinar, and then your tribal affiliation. If you have one, you might be a tribal employee and you don't have tribal affiliation, that's okay too. And then just a quick final note before I hand it off to Cheryl, that red menu panel that's all the way to the left-hand side of your screen. Yours might look like mine, or you might just see the symbols all the way to the left. But I just want to give you a quick note to try not to click on that during the webinar because it'll work. It'll take you to whatever you clicked on the menu and it'll pull you from the webinar. If you do accidentally click on there, just know you can always click on that green banner once again to join, and we'll see you in here. All right, folks, it's with great pleasure that I introduce your webinar instructor for today, Cheryl A. Cosley. And Cheryl, I have made you presenter now.
Thank you very much, Brooke. Welcome, guys, to day 3. As I said before, this presentation is courtesy of the Native Learning Center, also the Department of Housing and Urban Development. We fall under Native American programs. So welcome and good afternoon. I did go smudge. We usually start everything with a prayer. So I always do that. My name is Cheryl Cosley. My Anishinaabe name is Redbird Woman. I am Loon Clan. I come from the place of the pike in my language, which is Keno Shinkoning. That's the Bay Mills Indian community. Our reservation is located at the top of Michigan. of the Upper Peninsula, and our waters actually border Canada. We're a Ojibwe or Chippewa people, and I served as Director of Housing for my tribe for over 28 years. During that time frame, I served as the chairperson for the Great Lakes Indian Housing Association. That's a 31 tribes surrounding the Great Lakes area. I also served on the board of directors for the National American Indian Housing Council for over 16 years. I started out as the board secretary, went to the vice chair, and then I was a two-term chairwoman for 4 years. I started Cheryl Cosley and Associates in March of 2019. I provide training and technical assistance through the lower 48 and Alaska. I go up there a little bit too. So I've been blessed my whole life to be able to continue servicing our people. I've been in housing since 1999, so I've got a lot of years in, but you're constantly learning. I was sharing with Brooke earlier that I'm pouring over to CFR 200. They changed a lot of the documents under this current administration, some of the wording, things like that. So we always try to give you up-to-date information. So I'm working on a procurement PowerPoint that the numbers are out of whack, so you're always learning in this job, and it doesn't matter how many years you have in there, that's the way it goes. So please stick with us. Make it all the way through Friday. Hopefully you'll learn something, and I used to say, if I can learn one thing every day, I'm doing well. So to make that program of yours stronger, my information is at the beginning and the end of every presentation. Should you ever need anything, please email me, give me a phone call, whatever you need to do. I will always try to get back to you. If I'm teaching, like right now, it'd be at the end of the night. And if I'm on the road, which is often, it might be tomorrow, but I will always try to get back to you. So this course description, it's to help council members, but it's also anybody within your housing association, your tribe, that needs to know some of that background in NAHASDA and how we stay compliant. That's, one of the huge things there. To develop knowledge of the federal rules and regulations. We started out on day one, how to use all of our guidance information, so that's, one of the main objectives, besides for what are the responsibilities of the tribal council. You have the ultimate oversight for not only your housing program, but your whole tribe and those community members. And there's a lot of decisions within housing that sometimes need to go all the way up, to your level. And some of the things that we can undertake or change that will also need your permission. We talked about that yesterday with a tribally determined wage rate, so you're involved at various steps along the way. So hopefully, you're going to continue to learn the requirements. If you're not tribal council, there's still a lot here to learn. There's a lot of reference material. As she said, the first three are the statute, the regs, and part 200 of the Uniform Administrative Requirements. Those are the rules. Those are the rules we have to follow. There's also a lot of things like income limits. This year's income limits just changed about a month and a half ago. Calculating annual income under NAHASDA. That's a revised document finally. The other one I think went back to 2013. You need that for your occupancy, your admissions and occupancy. That's one of the most important policies that you're going to have. Assisting non-low income families. That's an area where you're going to determine as leadership if you want to do that. You can help them with 10% authority. You can help them if they're essential families. You can help if they fall under the law enforcement provisions. Those are decisions that you as a governing body need to make if you want to do that. The insurance requirements. When you're helping with NAHASDA funds, there's insurance requirements that kick in at $5,000 worth of assistance. You have to make sure that your housing department, authority, whatever you want, whatever you call it, TDHE, make sure that they comply with the insurance requirements, the useful life and binding commitments. And when you build, you stay within the total development cost. So that's all here. There's a policy status table. The information on a tribal wage rate, should you want to do that. Conflict of interest in housing admissions. Every application package for every program that you offer should have a page in there that asks the applicant if they have a relationship with the decision makers of the tribe within the housing authority, housing program, board of commissioners, if you have one, tribal council. You need, there's certain steps HUD requires that we take. So those are some of those reference materials. Self-monitoring plans. Ultimately, you guys are responsible for the self-monitoring to make sure that it happens. Either, the housing program itself does it, the board of commissioners do it, or, you as the council need to make sure that it occurs. Model activities, federal supply sources, GSA, our federal financial reports, and the administrative requirements should you want to invest those block grant funds. So those are all in your reference materials. Today we're going to talk about, finishing up with other various federal requirements. As I said, this is one of the most heavily regulated programs that your tribe will offer. And you as tribal council can help your housing entity. Share your environmental resource staff if you have it. Share your attorneys if you have it for looking over leases and policies and things like that. And then we're going to get into your participants. Bottom line, these are the people that we need to help. These are some of the rules. Like I said, I work all over the country, and I've seen cases where people interpret the rules differently. And, some of those mandatory deductions, I've seen tribes say, well, yeah, you can have childcare, but if you take childcare, you can't have the excess of travel. No, that's not true. You have to give all of those statutory deductions. Then if you want to offer more, it should be reflected in your meeting minutes and your IHP that we've changed these or added to. You can't take away from, you can add to. And then the payments, utilities, things like that. So that's what we're going to talk about today. Stick with us. Please stay, all the way through and come back tomorrow and the next day. So we're going to finish up with the other various federal requirements. Indian preference is huge, okay? You might have a tarot organization. And I don't know if I should say this, but I'm Native and I can. Sometimes they're a pain. If you have to work with them, make sure they're trained. Make sure they realize the laws that you have to adhere to. I used to do that with our judges. These are our laws. These are our evictions. Is there anything we need to do to strengthen it? Is there anything that you don't agree with here? Take that time, meet with them. Your tarot officers are the same way. This is what I have to do. Is there anything you'd like me to provide you? Do you have these, particular documents? Or do you have documents that maybe I could use? Get them involved if you have to use them, and make sure that you guys are both following at least all of the NAHASDA, requirements that we have. So those Indian and tribal preference requirements are TDHEs that adopt a tribal preference law have to comply with that tribal law in lieu of Indian preference requirements that would otherwise apply under, Section 7B of the Indian Self-Determination and Education Assistance Act. If your TDHE is a recipient, it has to comply with those tribal preference laws of your beneficiary tribe. If your TDHE is authorized to issue regulations and ordinances under tribal law, I don't know of any that are, but I used to write them and then ask them to look them over and perhaps, put them into law, especially when it came to things like res dogs and other things like that. You'll find yourself doing that the longer you stay with your program. So any regulations and ordinances issued by the TDHE that provide for tribal preference and employment and contracting will govern under your IHBG. And you'll see those. We're going to hire Bay Mills members first, and they're going to be the last in order of layoff. You can reverse the order, things like that, so try to find them. Your tribe probably has them in place already. Try to find a copy of that resolution. Put that in your depository of your policies. So Indian preference, we're subject to 7B of the Indian Self-Determination and Education Assistance Act. Tribal and employment opportunities given to our natives under 1015 of the regs, and preference of the award of our contracts at 1052. So that self-determination, that Education and Assistance Act authorized the Secretary of the Interior, of Health, Education, Welfare, and some other governmental entities to enter into contracts with, make grants directly to federally recognized Indian tribes. We're going to have, we're given the authority for how we administered the funds, which give them greater control over our tribal welfare. Preferencing the award of subcontracts and sub-grants in connection with the administration of those contracts and grants given to Indian organizations, Indian-owned economic enterprises, as defined within Section 3 of the Financing Act of 1974. So it's basically Native American preferred. So that final rule, it amended 24 CFR sections 48, 50, and 52 to provide for that tribal preference in employment and contracting. The most current guidance we have, and we've talked about that over the last couple of days, some of our HUD guidances are dated way back. There's some that we utilize that go back to 2002. This one goes back to 2013, but it is the most current guidance on this subject. So I believe it is also in your reference materials. Dated July 11th of 2013, it provides additional information on administering all of those, revisions. So you certify that you have policies and procedures in place, preferences in your procurement activities as outlined at 1052. Those clauses have to be incorporated into your contracts. You include preference references in all of your notices, all of your advertisements. It provides special opportunities for our Indian or Native American contractors in selection, mandates additional preferences that those contractors must offer their laborers, subcontractors, suppliers, to provide economic opportunity for our tribes, our Native Americans, our recipients, and our communities. You are not required to hire an Indian individual or a firm, but you have to take all of the steps to try to do so. So you put a preference in your solicitation process. It's required by federal and, sometimes or often your tribal law. You clarify your preferences right from the get-go. In your procurement policy, all your advertisements from the outset, to make sure that everybody is aware of that in your contracting. It's applied in the selection of your contractors, your vendors, in your contractor selection of their subcontractors and suppliers. It goes, downward. During employment training by the contractors. I used to tell them, we got a big job going here. I would like to see some of our Native people employed. What I'd really like to see is some certified tradespeople come out of here. We had a couple of projects where I think 4, 5, 6, came out as certified carpenters. And to this day, I believe they're still working in those fields. Give that opportunity to your people. So qualifying bidders, proposers, vendors, you specifically determine if the individuals and entities are qualified to receive Indian preference. You have to qualify them. They have to ask for preference. You don't rely on determinations that anybody else gives you. And you can always determine, right up to the point, I'm sorry, I don't agree with this. We're going to need some further information. Who's eligible? Members of federally recognized tribes, okay? I didn't learn this one until way in, I guess you would say. You were this many years old. Indian preference doesn't qualify for a state tribe. It's federally recognized tribes as a whole. And then you have entities at least 51% owned and controlled by the members or that tribe. So it controls voting rights, management, decision-making. You have to make sure that that's not, I guess you would say, a shill or that they legitimately have that control. Evidence, that it's owned. Must show evidence of 51% ownership and control. They should be able to cut a check, for one thing. That's one of the, and that preference must be requested. There's documents that are in the reference materials, for that. If not, I believe they are in the procurement and contracting class that I teach, and you could go back and get them that way. So you advise your bidders, your proposers, vendors, Indian preference is required in your contracting and your awards. Parties seeking preference has to request preference. When feasible, you provide interested parties an Indian preference qualification application. So there's a variety of approaches based on size, regularity, and the nature of the procurement that you're doing. The more thorough the process, the better. On large procurements, make that determination prior to the submission of your bids or your proposals. You can pre-qualify those firms and include a determination that that bidder is also a responsible contractor. When you get into procurement, you always have to make sure the people that you deem them responsive and responsible. Those are two things that you have to look for. When it gets to Indian preference and things like that, you could have somebody that you work with, all of the time, and they're very responsive, okay? And you find them responsible. But let's say you normally work with them and they build you 10 units of housing at a time. But this particular contract's for 50 or 100 units of housing. At that time, sometimes you have to pass them over, and you can explain to them why, it's not even the Indian preference that we're questioning. We're questioning your ability to ramp up to service a contract of this size. You don't have the labor, you don't have the finance, you don't have the machinery in place, things like that. So there's a lot of decisions when it comes to contracting and bidding that always try to find, 2 to 3 people that help you do that and make those types of decisions. I used, a professor from our college, a gentleman, the building trades, people, or, there's different people that have that expertise, and you're allowed to bring them in to help you make those determinations. So there's a variety of approaches based on that size, regularity, and nature of your procurements. Again, the more thorough the process, the better. Make those determinations early and make sure that you do deem that they are responsible. So use that Indian preference qualification application, require supporting documentation, establish that panel. You can use staff, you can use board members, you can use tribal members that have that background. Make an independent verification and inquiry. Watch for some of those fronting practices. It disguises how little profit that tribal member actually receives, or they appear on paper as 51%, but the management and control is with the non-native. Less than truthful in explaining resources that each owner brings to your entity. Document. Always, always, always document. Carefully record your decision in writing. Be prepared to provide further explanation to anybody that you disqualify, and make sure that they understand that disqualification is for the Indian preference portion only, and they can still submit a bid or proposal. You just can't offer them Indian preference. So reserve that right to reconsider. You can disqualify anyone, even if you've already qualified them, right up until the award of the contract, in case you become aware of information or that entity's structure suddenly changes. And you can actually, if you want, add contract provisions for the termination if that entity loses its Indian ownership or control during the contract period. And that was the reason that they were awarded that contract, was because you awarded them that Indian preference. So you can read about it at 24 CFR 1052. You certify you have a policy that's going to afford Indian preference consistent with, the Indian Self-Determination and Education Assistance Act. You can solicit bids from Indian-owned and controlled entities only, or you can use what they call a 2-stage method. These are various mechanisms you can do to meet Indian preference. when you solicit from Indian owned and controlled, when I teach procurement, one of the things that I say is 3 is the key number. You need to have at least 3 bidders usually to make HUD happy. The more, the better. The more you have, the better prices you're going to get. Sometimes it's hard, depending on the contract size, to get Indian preference of 3 or more. So a 2-stage method, you advertise for bids, proposals limited to qualified Indian organizations, Indian-owned enterprises, or you could use a 2-stage preference procedure. You know, the first stage, you invite or otherwise solicit Indian-owned enterprises to submit a statement of intent to respond to a bid announcement or request for proposal limited to Indian-owned firms. If you get enough responses from, you know, more than one Indian enterprise found to be qualified, and I actually disagree with this, 1 is not enough. You're not allowed to sole source. You need more than 1. You need like 3. Advertise for bids or proposals limited to Indian organizations and Indian-owned economic enterprises. Okay, so if any method for Indian preference results in only 1 bid or proposal being received, then you re-advertise it using any approved method of Indian preference, or re-advertise to all entities utilizing, you know, something like the X factor or other points or preferences that you have put into place. You can ask HUD, ONAP for approval. You have to justify in writing a contract related procurement documents in accordance with 2 CFR 318 through 326. You know, they will not allow you to sole source. They don't. It's just like, I've had to put things out 3 times for bids in my lifetime because I couldn't get people up to this area. So you have to be real careful there. So this is, you know, a demonstration of those X factors, you know, and it's a percentage of the bid, and it explains, you know, what that is here. So small purchase, Indian preference, the procurements that are within your dollar limitations established for small purchases need not follow that formal bid or proposal procedure, since those procurements are governed by the small purchase procedures at 2 CFR 320. Your recipient small purchase procurement shall, to the greatest extent feasible, provide for Indian preference in the award of your contracts. All preferences are supposed to be publicly announced in the advertisement and your bidding or proposal solicitation, your documents and your bidding, and, you know, all of those documents that you put forth. You can require prospective contractors to provide the following information before submitting a bid or a proposal, or at the time of submission. You know, that evidence showing fully the extent of the Indian ownership, the interest, the evidence of the structure, the management, the financing affecting the Indian character of their enterprise, including major subcontracts, purchase agreements, materials, equipment supply arrangements, management salary, profit sharing arrangements, evidence showing the effect of the extent of that Indian ownership and interest. Evidence sufficient to demonstrate to the satisfaction of the recipient, you, that prospective contractor has that technical, administrative, and financial capacity or capability to perform the contract work of the size and type involved. That's what I was kind of giving you the warning about. A lot of times they don't have, you know, that. Now, with Indian preference sometimes comes particular headaches, and I'm a very honest person about that. Your tribal members. I've, you know, had a tribal member that was in the trades that I used on a small contract, and he held up every single person behind him. So I documented it, and I told the tribal council. They said, well, he's tribal. And I'm like, yep, but you hired me to make sure that this was running correctly and I was spending the money the most efficiently that I possibly can. Why don't you give him one more try? So I did. And the same thing happened. So under our Constitution, our tribal council rolls every 2 years, okay? There's no term limits. They're not staggered. But there are times that I have experienced that the whole council almost will go away every 2 years if the tribe's not happy with how they are. So for the remaining 14 years, 16 years, every single time a new tribal council came in, he would go knocking on their door and say, you know, Cheryl at Housing won't give me these contracts because of the fact, you know, she just doesn't like me, but I'm Native and I'm from this tribe and you should give me that Indian preference. So it's really, really important that you document when they fail to work also, because just because they're Native does not mean that you have to also give them the job. You need people that can do that, keep you on time, not back up your other tradespeople and cost you money. That's just a little from the heart here. One of those things you have to watch for. But documentation is the key. So you can require that prospective contractor to provide all of that information and, you know, ask for their past customers, ask, you know, and call and get those references. How did they do? You know, so you need to incorporate those 7B clauses into your contracts and connections with projects funded. The work to be performed is on a project subject to 7B of the Indian Self-Determination and Assistance Act, Education Act. The preferences and opportunities for training and employment shall be given to Indians. Preferences in the award of contract and subcontract shall be given to Indian organizations, Indian-owned economic enterprises, and the parties to that contract shall comply with the provisions of 7B of the Indian Act. So, in connection with the contracts, your contractor shall, to the greatest extent feasible, give preference, you know, in the award of subcontracts to Indian organizations and Indian-owned economic enterprises. Preferences and opportunities for training and employment to Indians. And you'll put that, your contractors will actually put the 7B clause in all of their subcontractors. So it goes down to their subs. They should be hiring Native Americans also. At the discretion of the recipient, you will take appropriate action pursuant to the subcontract upon finding that the recipient or, you know, has violated that section 7B clause. So there's enforcement there also that you have to do. You shall not be required to apply Indian preference requirements under 7B with respect to any procurement that takes place using a grant from NAHASDA. Okay, NAHASDA is what permits this for goods and services with a value of less than $5,000. So there's a threshold there. 5,000 seems to be a common threshold for some of our triggers. Indian preference, you certify policies and procedures, your tribal code, your regulations are in place. Preference clauses have to be incorporated into all your contracts, and utilize Program Guidance 2013-07 to make sure that you are compliant. You should have the following documents: an Indian preference policy, an Indian preference qualification application, because they have to ask for that. Then you have to have that determination letter that you determine them either qualified or not, and a complaints policy for methods for providing for Indian preference. You got to have like 3 different complaints policies, by the way. Make sure that you have all of these in place, that your housing entity does. You know, this is a sample of an Indian preference policy, a qualification application, and your determination. You've either qualified them or disqualified. But then again, you make sure that you let them know that they're still allowed to bid. You just can't offer them Indian preference. And then your preference complaint procedure. Now, I work, like I said, a lot with policy. I had one when I'm looking at it, I'm thinking, something's wrong about this policy, and they had shortened the days on it. So of course I sent it to one of my people I call them my people. The Eastern Woodlands office was absolutely wonderful, but I now work, you know, with all sorts of offices, and I've got different people that I'll ask, hey, can you tell me about this, you know? So I sent them the policy and they said, no, Cheryl, you can't shorten the days. And I think they had went from 20 to 14. So make sure your preference complaint procedure follows 1054 and you don't shorten those days, okay? It's got to be 20. So this is also going to spill over into your employment and contract preference laws, okay? So the NAHASDA statute itself allows for you're applying your tribal employment and contract preference laws, including the regulations and tribal ordinances adopted by your tribe that receives a benefit, from the funds of NAHASDA. In absence of a tribal employment and contract preference law, you must, to the greatest extent feasible, give preference in the award of contracts over the same people that we just talked about, follow 7B. So preferences and opportunities for training, employment, and connection with the administration of the contracts, subcontracts have to be given to our Native Americans and Alaskan Natives. Preference in the award of contracts and subcontracts in connection with the administration of contracts be given to Indian organizations, Native-owned economic enterprises, as defined in Section 3 of the Indian Financing Act. So your tribal action, if your tribe passes and adopts a code and regulations regarding tribal preference, get a copy of it. Utilize that. You adopt the policy, make sure it's in your personnel policy, make sure it's in your procurement policy, and such law or policy can provide for preferential treatment over other Indians, okay? Giving your tribe, that Bay Mills member first, that are not members of your tribe in employment and contracting, in reductions of workforce and layoffs. So in hiring and in reductions of workforce. So there's your guidance. It is in your reference materials, and it walks through all of those areas where you have to make sure that you are compliant. So you're going to have multiple decisions to make, especially your tribal council, as it shapes the programs that you offer your tribal members. Many of these decisions are created as a result of the laws that we have to follow to make sure that we're NAHASDA compliant. The decision-making authority is dependent on how you've structured your housing program. As a tribal council, how involved are you in housing? Do you have a housing board of commissioners? And if you do you have a tribal council liaison? Do you receive a copy of the meeting minutes to keep you informed about the decisions affecting your tribal members? Now, I went through this, I think, on day 1. Your meeting minutes are so very crucial to your programs. If it is not in your meeting minutes, it did not happen. According to some HUD employees and your auditors, it's got to be in writing. You have to have permission. Got to have good meeting minutes. Now, you as a tribal council, if you are a separate entity, depending on how you're structured, if you do anything regarding your housing authority, TDHE department, make sure that you keep a copy of those meeting minutes and you send them over for those auditing purposes. They need to keep those. If you have a liaison, there's a couple other decisions that you should make with the placement of them on that board. If your board of commissioners get a stipend, does the tribal councilman or person sitting on that board also receive a stipend? Do you need them for a quorum? Does their vote count? Or are they just there in an advisory position? So you got to, kind of make sure that that's all outlined and given to the housing entity. So, the people that are overseeing that program or auditing it are aware of how that works. Now, my tribe did that. My tribe does that. They have a council person, and we don't have a big council, but in all of our areas of jurisdiction, they're on the Healing to Wellness Court, they're on the Health Board, they're on the Child Welfare Committee, they're overseeing our enterprises. Somebody is present that can go back and talk to the board and keep them informed about what everybody is doing. So that's common. Some of the other various examples about required tribal decisions. Do you offer tribal preference and selection? Do you have priorities? They would have to be in your A&O policy, but you're allowed to do that. Continued occupancy. Do you continue to service your tribal members in your low-income programs, when their adjusted income, is over 80%. You want them, that's what you want for your tribal members to succeed, depending upon your structure. Okay. I don't know if my lady here from Shawnee is in the background today or not. That area, you could probably get a rental product, because it's surrounded by a city. Where I am, this is the only thing that's here, unless you're able to get a private mortgage. Up in Alaska, and some of the villages I've been, those are it. So it becomes very difficult. So if your tribe has fair market housing, which we developed, then we in turn developed essential families housing. This is for our doctors and lawyers and things like that. Then we could say, okay, you make enough money, maybe 60 to 90 days, we'd like you to move over to one of these programs. It's going to cost you a little bit more, but it's going to be a different type of house, might be a little bit nicer, and you're going to have to pay a little bit more. Or you can say there's nothing else here. They're allowed to stay within that unit. And then you decide whether you're going to charge them the same amount or charge them more. You have to be consistent. HUD wants consistency with your tribal members. Okay, that's huge. So do you require them to transfer? Do you charge them the same amount? Or are you going to use HUD's formula that's in that document, that in your reference material, or fair market rent? And then providing assistance to non-low income families in those exceptions. Are you going to service your essential families or law enforcement officials? And we're going to talk about that today and those provisions. It's coming up right now. So those are additional decisions, especially when it comes to essential families. Who deems them essential? I was allowed to do that because I was there so long. Sometimes it's only the tribal council that can deem somebody essential. Other times it's the Board of Commissioners. So it depends on the structure that you have, or if anybody's ever asked that question. So your eligible families, are your ducks in a row? Some days I felt like I was blessed to have them there in a circle, let alone, they weren't in a row, but at least I had a loop around them, so we have eligibility requirements that we have to follow. Mandated NAHASDA eligibility. Have to be a Native American. Special exceptions apply. I've seen cases where, there's HUD monitoring findings for housing non-natives. They gotta be, part of that Native household, or they have to be an essential family, or the law enforcement provision, okay? Gross income have to be within those defined income limits. Special exceptions there also. So what's a family? I remember the first time I read the definition of family, I'm like, everybody's a family under HUD. Well, this is good, so the term family includes a family with or without children, elderly family, near elderly family, disabled, or a single person. Types of eligible families: low income, non-low income, essential, and law enforcement. You can serve any low-income Indian family that is within your Indian area as long as you describe that activity and the area in your Indian housing plan, okay? Definitional low income, 80% of median income. It's the greater of your Indian area or the U.S. median income limit. Persons making up a family: Indians, non-Indians, elderly, near elderly, disabled, single, minors, and students, okay? Sole occupant. You need within your program to determine if they are suitable or unsuitable for your program. You do not have to house everybody. You as tribal council, I'd be preaching to the choir. We would run the criminal background. The mechanism that we used, I had the ability, looking at the criminal lien, to disqualify some people, okay? Others, when it was iffy, I brought it to the council. Should I ever disqualify somebody, they had the ability to put it, to grieve that, okay? We had a procedure where, if they voted on it, they didn't know who they were voting on. They knew it was a Bay Mills member or a non-member. They knew it was a male or a female. They knew their age. They knew what they were charged with and what was the sentencing portion. That was it. Collected the votes. If there was enough to let them in, they got let in, and they never knew who they voted on. If they didn't, then they had the opportunity to grieve in person. Okay. Always had a lot of law enforcement, it seems like, on our tribal council, which is a good thing. And they would always, the chairman or the vice would say, can you tell us, about your situation? We need to tell you where we're coming from. We're the tribal council. We are responsible for all of our tribal community. Housing is an opportunity. It is not an entitlement. Can you tell me why you think that we should allow you with this criminal background in housing? And they would plead their case. Sometimes they'd let them in, sometimes they wouldn't. Sometimes they would have the lawyer drop an addendum to allow them in. And if they breached that addendum, it was do not pass go, you are out. No liquor in the household. No charges other than a traffic ticket. No domestic violence. No guns. All sorts of different ones depending on the reasoning that they were there. So that's a really important role that the tribal council, depending on your situation, who hears those hearings also. That unsuitability is determined by the recipient, the tribe, the TDHE. Some of the examples: a violent criminal background, a drug-related criminal background, especially when it comes to manufacturing. You don't want that in your housing. Poor history related to previous housing. My tribe, at least, you were not allowed to even apply for one of our programs if you owed the housing authority money. You pay it in full, then we're willing to take your application again. Depending on why you owed so much money, if you trashed a house, we might double your security deposit, but you weren't even allowed to apply. If they were in debt to the tribe or the TDHE, because we also ran the utilities, the water and the sewer for the tribe. So your low-income family, a family means a family whose income, a low-income family, means someone whose income doesn't exceed 80% of the median income for your area, as determined by the secretary, with adjustments for smaller and larger families, except that the secretary may, for purposes of this paragraph, establish income ceilings higher or lower than 80% of the median income for the area on the basis of the findings of the secretary or agency that such variations are necessary because of a prevailing level of construction cost or unusually high or low income families. I've seen all the cases. I've seen where the income's the lowest of the low. And I've seen some of those incomes, of like our Aquina Wampanoag and our Mashpee and areas where they're in really affluent areas, Actually, even when you get to some of the pueblos and they get close to, Santa Fe and those places like that, or when you get up into Alaska and you have to barge everything in order to build it, that affects everything. So that term median income means, with respect to an area, an Indian area, the greater of your median income for your Indian area, which the secretary is going to determine, or the median income from the United States or for the United States. You have to use the highest amount. You want to qualify as many of your families as you can. So Section 4 of NAHASDA defines median income with respect to an area that is an Indian area, the greater the median income for the Indian area, which the secretary shall determine, or the median income for the United States. So my sister tribe, for instance, they're 20 some miles away. They're in 7 counties in Michigan. So once a year, when it comes out, the income limits, they came out, I believe, in May. The brand new ones are attached in your reference material. So if you haven't updated them, please do so. They look at the highest income of all of their 7 counties. Then they take that highest one and they compare it to the US median income. And the highest one there is what they use for the year. That's how you do it, okay? Only have to do it once a year, but that's what you do. So depending on the county in which you're located, the median income for 2025 is $104,200, okay? And then it's broken down by size. So depending upon how many people you have in your family, and then that I just quoted you was for a family of 4, but that was at 100% in median income. We go for the one that is at 80% or below, okay? So now for a family of 4, it's $83,360, okay? And there's deductions and things that come into play for this also. So those numbers change. Make sure your staff's using the most current numbers available. If you are in charge of writing the policy or approving the policy, your A&O policy should say that you're going to use the most current published, guidance as far as income, and it will be an addendum placed in your policy yearly. So you don't have to go in and every time that comes out, readopt your policy. Because unfortunately, I've been at places where they had turnover and they really didn't know, and they were going by their policy and it was attached, and they were using income limits that were like 3 and 4 years out of date. They had so many families that, they go up every year. Sometimes they jump a lot. Sometimes it's, a couple of $1,000s. I'm like, can you grab everybody that's applied for housing in the last, 4 years? And we need to send them a document saying, if you're interested in housing, these are the income limits that you have to fall under. Because you don't want that to happen. So make sure that somebody is on the Code Talk website. Like I said, every single day, get on that Code Talk website. That's where everything's at. Check your income limits. Always make sure you're using the most current one. So I explained how you go through if you're in more than one county. So it defines median income with respect to an area that is the Indian area, the greater of the Indian area, which the secretary is going to determine, or the median income for the United States. Then that other document that I talked about, that 2024 document, it tells you about your calculations of income, okay? You need to adopt a definition for your tribal housing policies. Which one of those 3 income definitions are you going to use? Then you need to apply the NAHASDA exclusions, and then the federally mandated exclusions, verify the income, and that is their adjusted income for purposes of determining the rent. So this policy walks you right through all the steps. It would be a good learning experience for some of you to pull your policy and then pull this document and make sure that you're going through all the steps, or it's all included in there. There's the 3 definitions of annual income. In years past, I have heard where they said, if you don't want to pick one, you can say, we're going to use the definition most advantageous to our tribal members. I've seen a couple of people that said most advantageous to the housing authority. Be aware that if you do that during some of the auditing, they're going to say, show me where you ran it all 3 ways and that you picked the method that was most advantageous to your tribal member. You're tripling your work if you do it that way, okay? The other thing is, pick a good definition so they can clearly understand what they need to do to follow each one of those definitions and what applies to that. As well as to make sure that you don't also get into, you have to make sure you treat all your tribal members the same, okay? So your A&O policy, like I said, is the most important policy you have. It speaks to the exclusions of income. There's different, and that's a good thing because this is just updated. The other one went back to like 2011. So it gives you the most updated federal exclusions in the appendix items. So make sure you keep all your A&O documents in a binder. I could go over there and grab mine. When I teach that, I try to teach them, okay, you need this, 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 and this in here, so you know where to look to answer these questions. So we have those federally mandated exclusions published January 31st of 2024. They were in the Federal Register. I was just excited when I saw them. And then they were actually, they're Appendix D of this particular document, this reference. So make sure you're using that. You verify the income. Require your recipient to verify the income is eligible based on anticipated annual income. Okay? So when they're on your waiting list, you deem them eligible or not eligible. But if they've been on that waiting list any more than 30 days, you need to make sure that they're eligible before you put them in there. Okay? It's really, really important. You have to keep proof of eligibility for the whole time they're in those units. If they're in there 20 years and the file gets this thick, you move the proof of eligibility from file to file. You never know when they're going to pick which file. Your auditor will do it. HUD will do it. I got a finding for somebody that was placed in housing like 6 or 7 years before I even got there. You know, I didn't put them in there, but they weren't income eligible. Well, they didn't have proof of eligibility in the file. Okay, so make sure you keep that. Move it from file to file. Make sure that they are eligible. Run them right before you put them in there, okay? Your A&O policy should read, if they refuse to give you forms of income verification or they refuse inspection, those will be grounds for eviction. Why? Because you have to do it. Your housing program has to do it. Nobody has the right to say, no, we're not going to give you this. I'm sorry, then you're not qualified for our program. That is one of our requirements. So you got to make sure your A&O policy talks to that also. Okay. There's different, and you can learn about this, take an A&O class, forms of verification, third party, second party, first party. Okay. Me and my way my brain works, I always thought first was better than third. Well, in this order, third party is better than first. But, you know, they don't want the tenant basically bringing the information. They would rather the housing authority receive it directly from the employer. Okay. So adjusted income for purposes of determining rent, there's a dependent deduction of $480. Anybody under the age of 18, students that are not the head of household or the sole occupant, a person with disabilities, elderly and disabled families, an elderly or disabled family, and we'll discuss this. When it's elderly or disabled, you have to be the head or the co-head that is elder or disabled, okay? It's not your daughter who's disabled. It's not your mother-in-law that's living with you that's an elder. It has to be the head or the co-head or the sole occupant, okay? There's medical and attendant expenses, childcare expenses, earned income of minor, travel expenses, other amounts, okay? 203 NAHASDA requires you develop those policies governing your rents, homebuyer payments, charge for your assisted dwelling units, including the process and procedures for determining their eligibility. And then you adjust those rents accordingly. The most important part, remember, you cannot charge a low-income family more than 30% of their adjusted income, that month of their monthly income, okay? It's really, really important. You'll have to pay it back if you do. So that's one reason you recertify everybody. I've seen tribes that say, you know, they're at the max rent. We don't need to recertify them. Well, you have to be able to prove you're not overcharging them either. So yeah, you should be recertifying them. So the annual income definitions, Section 8 definition, census definition, IRS definition, okay? If you're utilizing the Section 8 definition, you have until the end of 2026 to incorporate the changes that were brought, and we'll discuss that in a minute. We'll discuss that right now. HUD revises the Section 8 Part 5 definition of annual income, okay? this first document came out in 2023. It gave us until January 1st of 2024 to make the changes and apply the changes if you were using that definition, or if your tribe was using one of the ones saying that you're going to utilize all three definitions. Well, now you got to change your A&O policy to incorporate that. It gave them, like I said, until the end of the year to make these changes that were brought about by what they call HOTMA. HOTMA was signed into law in 2016, and it's taken this long to basically kick in. It revises Part 5 definitions of annual income, a couple of the deductions, things like that. So HUD published a final rule implementing that on February 14th of 23. It gave the tribes anytime between January 1st of 2024 and January 1st, 2025 to come into compliance with HOTMA. Me teaching the A&O class was like, my poor ladies at HUD. Have you seen anything? Have they changed anything yet? You know, we're running up on the deadline, you know. So there was then a subsequent publication that came out. It came out, PIH Notice 2024-37. It was issued in December of last year. That amended that, so we have until January 1st of 2026 to come into compliance, okay? They're going to publish something like this that tells you what you have to change if you are using that definition, okay? So look at your policies. If you're using that definition, or you're using the definition saying that you're going to utilize all three, you are going to have to watch for this announcement and change your A&O policy to come into compliance by January 1st, okay? Hopefully they'll send out a big broadcast blurb. Anything that I teach, I'll make sure that everybody knows, you know, any of my past students, that's when I go and work with their reservations, I always try to keep them updated on things like that. So watch for that. That'll be a code talk, you know, thing. So whose income counts? Employment income? Everybody basically except the dependent or a live-in aid. You never count anything for a live-in aid or the income, employment income of a foster child, okay? So other income, you pretty much count it all unless it's a live-in aid or a foster child. In this case, you wouldn't count the other income of a foster adult, okay? So income exclusion categories, benefits that shouldn't be counted as income, they're within that guidance. Certain VA benefits, the certain benefit, you know, people that you don't count, such as the live-in aids, and amounts that are counted as an asset rather than income. For example, inheritance. Income from self-employment, cash assets withdrawn or salaries paid to household members from businesses have to be counted. Losses are counted as zero. You don't deduct them. Alimony and child support. There's special rules depending upon the definition that you use. And if they actually receive the child support, if they don't receive child support, they can go to their court of jurisdiction, tribal court, state court, and they can prove, you know, that they're not receiving that money. You can adjust that payment, okay? If it's not received, document the delinquency was reported. You include it if it was received. You don't if it wasn't. Assets, there is no asset limit. Income from assets is recognized as part of your annual income. When does your family have to be low income? Depends on what program you're servicing them with. Rental housing, when the lease is signed with the family, when they're moving in. Home ownership, when the mortgage is signed with the family. A rehab program, when the agreement is signed with the family. If it's rental assistance, it's when the agreement is signed with the landlord. Your eligible families, assistance for eligible housing activities under NAHASDA are limited generally to your low-income Indian families on your Indian reservations and your other Indian areas. NAHASDA specifically identifies 4 types of families that you can assist. Low-income Indian families, you can utilize, if you want, use the reference materials, 10%, they call it a 10% authority for your families that fall between 80 and 100% of median income. You have to, talk about that with the governing body, or if you are the governing body, you need to make that decision. You need to put it in your IHP that we are going to utilize the 10% authority and service 10% of our families that fall between 80 and 100% with our programs. There's rules for them. They have to be charged more in the majority of cases. Even like down payment assistance, there's a calculation. If we're going to give everybody $10,000, you run this calculation, they might only be eligible for $8,500. So there's rules that come to helping your over-income people. They cannot receive the same amount of assistance as your low-income families, okay? And you have to track that authority. Somebody has to track that 10%, okay? Your essential families, if you decide you're going to service them, and your law enforcement, should you decide you want to utilize that. So eligible Indian families, you can serve any low-income Indian family as long as it's in your Indian area. That activity, that area is described in your IHP. Definition, again, of low income is 80% or less of median income, greater of your Indian area or the U.S. median income limits. Your adjusted income is used to determine those payments. Payments are calculated based on the household adjusted income, not the gross income. Payment for rent, home buyer cannot exceed 30% of that household's adjusted income, okay? No matter what. 30% of zero is zero. You'll get in trouble. Income eligibility has to be verified at the time of the initial assistance, payment calculated at the time of assistance. You have a talk with your tenants when you put them in. I used to do it as the ED to make sure that they knew about it. If you have any type of life-changing event, you need to come and talk to me. You need to come and talk to somebody here within the housing program. If you have a baby, if you become a senior, if you lose a family member, if somebody moves out, if you get a new job, if you get a big raise, if you, lose a portion, if somebody gets fired, all of these things, we're not allowed to charge you over 30% of your income. Yes, in some cases it's going to go up. Now, if you come in and tell me that it's going to come up, I'll give you an extra month to put that into, the end of this month and then another month before it kicks in. If you don't tell me and I find out, I'm going back to the day that you got that raise or, whatever. That was the incentive I got to make them come in. You have to do that. You have to make sure that they realize why it's so important that they let you know when things like that happen. Let me know when you become a senior. There's going to be deductions that come into place. So your income eligibility has to be verified at the time of the initial assistance, payment calculated at the time of that assistance, and you have to keep verifying that. Verify by third-party verification, copies of wage and bank info, income tax returns, utilize affidavits of no income. So that portion of that job is hard, your A&O. So your adjusted incomes derived by subtracting any of the deductions or allowances that apply to your household from their annual gross income. The eligibility depends on what type of household they are. Not all households are eligible for all deductions. Special rules apply for the head of household, the spouse, the co-head, or the sole member. There's certain things that can happen only if you're in that position. There's other things that can't happen if you are in one of those positions. So your staff needs to know what it is. So when it comes to annual adjusted income, that family's payment is based on the percentage of income. Their annual income first has to be adjusted. You take their annual income minus those deductions. That is their adjusted income. So there's statutory exclusions and deductions that you must give. So make sure that you have policies for all of these also. Your dependent deduction. You students, persons with disabilities. $480 for every family member residing in the household other than the head of household or the spouse or the sole occupant who is under the age of 18 or who is 18 years of age or older, and they are the person with disabilities or a full-time student. Okay? Elderly or disabled families. There's a $400 elderly or disabled family deduction. This is another thing you need to address in your policies. Our tribes love baby elders and near elders. Are they going to be eligible for the elder deduction? Okay. Under this law, and unless you change the age, they're not. Okay. It's the full elder age. So medical and attendant expenses over 30% of their income. Medical only if they are an elder or disabled family. Reasonable attendant care and auxiliary apparatus expenses. Child care expenses that enable a family member to work or to go to school. Earned income of minors under the age of 18. Travel expenses not to exceed $25 per family per week, not to exceed $1,300 within the year. For employment or education. Other amounts that are provided for within your Indian housing plan. When you make any change to these statutory exclusions or deductions, or you add anything in, it has to appear in your Indian housing plan. Okay? So, the rules for a full-time student. If they are not the head of household, the co-head, or the sole occupant, a full-time student will be eligible for a deduction of over $480. Okay? If they work, you count the first $480 that they make, and then you don't count anymore. Okay? You need to actively make sure that they are still in school, and build your provisions around this, because in some cases, they could make a lot of money and still be in school. My son is a full-time student and works 2 jobs on top of it. Okay? He's not here, but he also realized at the age of, he started working full-time when he was 15, the day after he turned 15, that he made more money when he wasn't on my taxes. So it depends on your rules also. Do they have to be a dependent on the taxes? So your adjusted income used to determine payment. Payments are calculated based on your household's adjusted income, not the gross income. Payment for rent or home buyer cannot exceed 30% of that household adjusted income. Your income eligibility has to be verified at the time of the initial assistance. Payment calculated at the time of assistance. You verify by either third-party verifications, copies of wage, bank info, income tax returns, utilize affidavits of no income. This is the guidance that's in your reference material that deals with everybody that is not 80% or below median income. Okay, that's your NAHASDA, your essential families, that's your law enforcement, that's your 10% authority, and these are the calculations that you have to do, all within this guidance. It's really important. Okay, eligible families, except as provided under paragraphs 2 and 4, except with respect to loan guarantees and Title VI assistance. Activities under this act shall be limited to low-income Indian families on reservations and other Indian areas. And then there's the exceptions. And the limits, the Secretary shall establish limits on the amount of assistance that can be provided under the act for activities for families who are not low income. So it's basically a 10% you're allowed to service, okay? So essential families, notwithstanding paragraph 1, you can provide housing assistance, provided through your housing activities assisted with grant amounts for a family on an Indian reservation or other Indian area if you determine as the recipient that the presence of the family on your Indian reservation or other Indian area is essential to the well-being of your Indian families, and the need for housing for that family cannot reasonably be met without such assistance. Okay. So you have to have a policy in place and a checklist basically showing, that the need for your moderate income. Okay. And then there's the law enforcement officers. A recipient can provide housing or housing assistance provided through affordable housing, assisted with grant amounts for a law enforcement officer on an Indian reservation or other Indian area. And there is specific criteria that they have to fit. Okay. They have to be employed full-time. They have to be an arresting officer. They can't be a dog catcher. Okay. Employed full-time by the federal government, state, county, or other unit of local government, lawfully recognized tribal government. Implementing such full-time employment, they are sworn to uphold and make arrest for violations of federal, state, county, or tribal law, and you determine the presence of the law enforcement officer on your Indian reservation or other Indian area may deter crime. So you also have to make that, statement. So your non-low income family is one whose income does not exceed, or your non-low income family is one who falls between 80 and 100% of the median income limits. They have a need that cannot reasonably be met without your assistance. Some reservations that are villages and pueblos and rancherias, you're the only thing that's in town. So that's pretty easy to have the criteria for. Housing assistance for non-low income families requires HUD approval, as documented at 1106, 108, and 110. If you plan to use more than 10%, plan for your tribal program year for assistance, you need to get HUD permission. Or if you want to help somebody that is over 100% of median income, you need HUD permission before you assist them. In cases where HUD approval is not required, you still must determine and document you have a housing need for non-low income families that is the need, and that need cannot reasonably be met without your assistance. So how many low income families? 10% plan for the tribal program year, families that fall between 80 and 100% of median income without HUD approval. If you utilize more than 10%, HUD approval is required. If the household income is greater than 100% of median income, HUD approval is required in advance of servicing the family. A 10% cap on assistance to families does not include families who are initially low income, but later experience an increase in income. You need to address that in your A&O policies. What you're going to do with them when they're successful and they're no longer low income. Are you going to let them stay in your program? And are you going to charge them the same amount, or are you going to charge them more? Okay. You have to determine and document you have a need for housing for your families that cannot reasonably be met without such assistance. Okay. You don't have to do those for those ones that age in place kind of. Examples of required documentation: property inspections, evidence of living in temporary housing, verification of family income, rejection letters from lenders or landlords, letters stating that the family doesn't qualify for any other federal, state, or local housing programs. So you need to develop a non-low income assistance policy if you don't have one, and a moderate income checklist, such as this. Basically, and it's got, the criteria for how you're going to verify that they are no longer low income. There's, part of your checklist. Maybe they have no child safety measures in their house, no insulation, lack of water pressure, inadequate cooling. It's a fire hazard. It's pest infested. It's overcrowded. It's got, poor or improper plumbing. You build your criteria. Okay. They're in temporary housing. They're living with relatives. They're in motels, hotels, in shelters. The family desires a residence on the reservation or within your village or pueblo or, rancheria. And you make sure that should you hit any of those thresholds, you obtain HUD approval first. You submit a proposal to provide assistance to your non-low income families as part of your Indian housing plan, or you request a proposal as an amendment to your IHP. Make sure you submit a special request if the family is over 100% of median income, or you wish to exceed that 10% authority. Your essential families can receive assistance if the family's housing need cannot be met without your assistance, and you determine that the non-low-income family's presence is essential to the well-being of Indian families living on the reservation or Indian areas. Now, I have seen some applications where they'll say, do you deem yourself an essential family? That shouldn't be on your application. That is totally up to you and your governing body to decide who is essential. Shouldn't be part of the application process. So that policy, that reference material, it's not a policy. Your reference material is at 2014-02. It's in those documents. Make your determinations about each essential family. Document your determination, even when HUD approval is not required, and use the guidance within that notice. Have an essential families policy. Make sure that you can deem them no longer essential, okay? Horror story. No, actually. You let somebody in because they're essential because they're a dentist, and then maybe you're in one of the pueblos and there's like 17 of you in a small circumference, and they take that new job, but they want to live in your housing because it's nicer than the one that is at the pueblo that they're at, or they don't offer housing. You need to be able to say, no, you are supposed to be essential to us. We deem you no longer essential. Hit the road, Jack. You know, so no, you don't tell them that, but you ask them to leave. You deem what is essential. Okay, this one comes from mine old. Medical personnel, dentists, school personnel, public safety officers, Coast Guard and other military, firemen, employees of the tribe, spiritual leaders, preachers, others determined by, in my case, it was me as the executive director. Your governing body decides who deems them essential, okay, and that should be in there. And then you should also have essential families will be requested to leave the program when deemed no longer essential. So track your 10% authority. If you're a small tribe, for instance, you get $365,000 a year. Your authority would only be $36,500. You have one family, you're helping them with fair market, $698 a month. That comes out to $8,376. Second family, you're helping them with home ownership assistance at $850 a month. That's $10,200 a year. Third family, you're going to give them down payment assistance. They qualified for $7,400 after you did that calculation. It comes out to $25,976 worth of your authority. It would leave $10,524. You have another family that comes in and they require $10,700 worth of funds. You have to get a hold of HUD and say, hey, I'm this much short. Can I service this next family? And you get permission in writing. Okay. So the summary of requirements for servicing your non-low-income families, if they're essential, they don't need HUD approval. You don't need to charge them more, and they don't count against your 10% authority. Same thing for the law enforcement. Continued occupancy, don't need HUD approval. It's determined by you if you want to charge them more, and they don't count against your 10% authority. If they fall between 80 and 100%, they still don't need HUD approval. You do need to charge them more, and they do count against your 10% authority. If they're over 100%, yes, yes, and yes. If you've hit your threshold, you need that permission, okay? So, policy required decisions. The 10% cap on assistance of families between 80 and 100% of median income do not include families that are initially low income, but later experience that increase in income. You have to address that in your A&O policy. Your decision. Are you going to continue to service them? If you're not, give them 2 to 3 months to find a place. It's not easy to move a house and find someplace else to go. And if you're going to charge these program participants more than your low income. In this particular case, you don't have to charge them more, but you might want to, okay? Detail your decision in your policy. So calculating rent for a non-low income family, you have to charge them either a fair market rent or you do a calculation that is within that document, okay? As an example, 80% of the median income for a family of 4 in Seattle, $75,040. The rental payment for a family at 80% of median income is $1,200 a month. A fair market for a 3-bedroom is $1,793. That's my warning. A non-low income Native family of 4 earns $88,000. So that's what I basically just told you. You take the income of your non-low income family at $88,000. You divide that by the income of your low income family at $75,040. That comes out to 1.17. You multiply that times the rent of the low income rent. Rent at 80% of median income is $1,200. Your rent for your non-low income person is either going to be $1,404 using that calculation, or you're going to charge them that fair market rent of $1,793. You have to, in your policies, write down, we're either going to use the formula or we're going to charge fair market rent. You can't, within the same program, okay? You can't, within the same program, charge one person one thing and charge the other person something else. You have to remember that consistency of your tribal members, okay? Put it in your policy. So your calculations, eligibility, rents should be determined in accordance with your policies. When determining those payments at 80% of median income, ensure that that adjusted income, you have all those deductions comparable, to your non-low income family, what they would use. In other words, the adjusted income of your low income family at 80% of median income should be based on the same family size, and the adjusted income deductions such as $480 for each family member under the age of 18, $400 for an elderly family, an overall rent cap for the unit that non-low income family would use. So your other assistance, okay, including down payment assistance to your non-low income families, again, can't exceed the amount of assistance that you're providing your low income families. So you have to, again, do a calculation. The present value of the assistance has to be the current value of the assistance at the time provided. So your income of your low income family at $75,040 divided by your income of your non-low income family is $88,000. That comes out to 0.85. You take the 0.85 in the example of down payment assistance, we give out $10,000, okay? 0.85 times that $10,000, your non-low income family would not be eligible for the $10,000. They would only be eligible for $8,500. So this is an area where we have a lot of slippage, okay? Make sure that your guys are doing those calculations right. Print off that guidance and make sure that they're doing that correctly, okay? So how long does HUD have to review and act on a proposal to provide assistance to a non-low income family or a model housing activity? Whether you put it in your IHP or any other time you amend it, they have 60 calendar days after they receive the proposal to notify you in writing to provide, about the eligibility, or if they agree to apply that assistance to your non-low income family or that model activity, if it's approved or disapproved. If no decision is made by HUD within 60 calendar days after receiving the proposal is deemed to have been approved by HUD. Your provisions for the law enforcement are found under the NAHASDA statute. It's the statute itself which allows that. Make sure that they meet all that criteria. We utilize that here. We also put them in our fair market housing. We have some of the nicest housing in this area, but it's got a lot of law enforcement in it. I used to say, please put those cruisers out where we can see them. I have a state policeman that's next door to me now. You're around the corner and there's Fish and Wildlife. There's another state policeman. There's a sheriff. There's tribal police. It's a way to keep your community safe. When they see that much law enforcement around, they're going to think, well, we need to, go to a little bit of a different place. You make that determination that it can deter crime, and it does. We don't have any gangs, anything like that here. So your eligible families, preference for tribal members, other Indian families, your Indian housing plan can require preference for housing or housing assistance provided through those activities to your members of your tribe or other Indian families, okay? Make sure the housing activities that are assisted with grant amounts are subject to those preferences, okay? So we have that exemption, Title 6 of the Civil Rights Act of 64, Title 7, no, 8 of the Civil Rights Act shall not apply to actions of federally recognized tribes and tribally designated housing entities of those tribes under this act. We don't have to follow the fair housing because we get the money to benefit our low-income Native Americans. So the regulations at 120 permits you to provide preferences to your families, members of your tribe, or to other Indian families. If you've adopted preferences in your admission and occupancy policy, you ensure the housing activities funded under NAHASDA are subject to those preferences. So this last part is pretty quick. It's your maximum and minimum payments. You can read about them under 1,124. You cannot exceed 30% of the adjusted income of a family that is at or below 80% of median income, okay? Can you charge a flat or income adjusted income? Okay, this is what the regs look. Remember the question and answer format? This is coming straight from the regs. The question is, may a recipient charge flat or income adjusted rents? The answer in the regs is yes, providing the rental or homebuyer payment of the low income family doesn't exceed 30% of the family's adjusted income. So I've heard, no, that's an administrative fee. No, unless you are running that mutual help program, your rents and stuff, 30%, okay? Remember, 30% of zero is zero. Is income verification required for assistance under NAHASDA? Yes, you have to verify that family is eligible based on that anticipated income. You're required to provide that documentation, and you as a recipient are required to maintain that documentation on which you made that determination of eligibility forever. You may require a family to periodically verify its income in order to determine housing payments or continued occupancy. You're doing it also to prove that you're not charging them over 30% of their income, okay? Make sure that your policies read that if they don't supply you that income or they refuse your inspections, remember your boots are supposed to be in every unit that you have once a year, that it is grounds for termination. So can you charge a non-low income family? Yes, once they exceed that 80%, you can charge them more. Matter of fact, you have to under most cases. Utilities. Under the 37 Housing Act, we were required to charge or give a utility allowance. We are not anymore, okay? And it is very costly. I'm going to tell you, unless you have a really strong collection policy, a really good tribal council board of commissioners that stand behind you, and you follow that collection policies, it's almost impossible to get all of the money that you are owed. Okay, it's called a tenant account receivable. You need to go after that money. You need to actively, regardless of who it is, get that payment. The minute that you quit doing that, it's like a big cause and effect thing. Everybody will quit paying. So, we're subsidizing with the money that we're supposed to be providing other services for those rents. So utilities can be considered a part of the rent or the home buyer payment if you decide that you want to do that. But, it costs a lot of money to run a project. You can define rents and home buyer payments to exclude those. So insurance, we have a lot of slippage here, guys. You need to require insurance. Okay, we have to insure everything everything that is of value to us, okay? I'd kind of looks at it like, if it could be insured, it should be insured, because we're not going to replace it if it should have been and you didn't insure it. Now, when it comes to your tenants, you're going to insure the dwelling, and you should be telling them that you would, highly recommend contents insurance or whatever. But you need to provide adequate insurance by purchasing insurance or by indemnification for casualty loss by providing insurance in adequate amounts. 2, indemnify the recipient against loss from fire, weather, liability. If you're providing assistance over $5,000 in value, you're supposed to require insurance on that. It goes hand in hand with your useful life, guys. The recipient shall not require insurance on units assisted by grants to families for privately owned housing if you have no risk of loss or exposure to the recipient, or if that assistance is in an amount less than $5,000, but will require insurance when repayment of all or part of that assistance is part of the assistance agreement, which kicks into that useful life and binding commitment. Okay, so you always need it out of your contractors and subcontractors. And you need to also follow the flood insurance requirements at 1038. Insurance is adequate if it's purchased insurance policy from an insurance provider or a plan of self-insurance in an amount that's going to protect that financial stability of your program. So this last statement is talking about Amarant. Okay, Amarant is owned by the tribes that utilize that insurance product. Recipients can purchase the required insurance without regard to competitive selection procedures from nonprofit insurance entities which are owned and controlled by the recipients and which have been approved by HUD. If not, what does that mean? If you're not utilizing Amarant, you need to go get at least 3 bids and procure that right, okay? If you're utilizing Amarant, you don't need to go through the procurement. Okay, may a recipient use grant funds to purchase insurance? Yeah, you can. All insurance purchases with insurance has to be in accordance with 1136 through 138. This kind of opens Pandora's box, guys. If you're going to provide insurance for one tribal member, you know, you're supposed to be treating all of your tribal members the same. So you should be providing it almost for all of them. So you got to kind of look at it that way. Try not to get into that. Or you can make the exception that perhaps you're just going to pay for your elders. You know, whatever you're going to do, put good thought into it. It's going to cost a lot of money. You got to treat all your tribal members the same. So the guidance, you know, when is that insurance required and in what amount? So that's what it pretty much tells you. Your useful life affordability period of a recipient, determine the repayment or forgiveness agreement for part of that assistance in privately owned housing units and housing units assisted with those funds. They have to remain affordable for that useful life. Therefore, as long as the useful life or affordability period is not expired, that assisted housing owned and operated by the recipient has to be covered by adequate insurance. So it's dependent pretty much about, you know, how much money you put into that. So read that guidance, okay? The examples, when housing units, do they have to be insured? If you provide $3,500 in emergency assistance to a private homeowner, it's not subject to a repayment agreement, no insurance requirements apply. $5,000 is the threshold usually for useful life. So when must it be insured? Well, if you provide $25,000 in down payment assistance to a private homeowner, includes a mandatory 10-year useful life or affordability period for the property and a 5-year repayment clause, then the insurance requirement described will apply for 10 years from the date that assistance is provided. So this is a sample policy. Housing funds shall not be spent on acquisition, construction, rehab of any home or parcel of land not insured against casualty, fire, or flood if necessary. Any home in a floodplain as delegated by, you know, your tribe's environmental resource staff or whoever does that, shall be adequately covered for flood damage, destruction to the home. The foregoing requirement shall commence at the time housing funds are first spent and continue the entire time in which the housing entity has a financial interest in a home or a parcel of land as applicable. You know, the programs such as rental assistance, student temporary housing, emergency assistance who have not exercised the option to purchase under a lease program shall not be required to insure the housing unit or rental unit. Nevertheless, the housing entity shall encourage participant to procure renter's insurance. The housing entity shall be named as a loss payee, this is your language, under all required insurance policies for the period of the conditional grant under a program or until the conditional grant obligation is satisfied. The participant shall provide the housing entity with certificates of insurance evidencing the required insurance. Okay, so that goes hand in hand with the useful life that we talked about yesterday. I did it again. We're 10 minutes over. I'm not counting all my intro slides as well as I should, and I tell you too many stories. But thank you for sticking with me, guys. I hope you enjoyed it. Please come back tomorrow.
Folks, I've already stuck the webinar feedback survey in the chat for you. You should be able to click that link. It's anonymous. You don't have to worry about your name or your email or anything being attached to it. It takes about 2 to 3 minutes tops to complete, and it does let us know what we can improve upon and what you are already liking with the Cathedra webinars. We also share the feedback with our instructors, so it helps everybody involved. We hope you can join us for day 4. That is tomorrow, same time, same place. So that's 2 p.m. Eastern, 1 p.m. Central, 12 p.m. Mountain, 11 a.m. Pacific, and 10 a.m. Alaska. Check out our other recorded webinars on our YouTube channel. We have a playlist called the Cathedra Webinar Archive. There is a link for that in the shared notes. And feel free to check out our other upcoming training events. We post about it on our various social media. You can find us on Facebook, Instagram, LinkedIn, Twitter. And we have a podcast for any of you podcast listeners in the house, the Hope a Thing, a Native American podcast. But otherwise, that is all we have for you today. Thank you, Cheryl, for another incredible webinar. We are more than halfway through, I guess, technically.
We are.
But we will see all you folks back here tomorrow for day 4.
Sounds
Hope
good.
everybody has a fantastic rest of their day. Sorry, what was that, Cheryl?
I said, thank you, guys. Come back.
Thanks, Cheryl. I'll talk to you tomorrow.